Okay, item 8, citizen opportunity to address the council on general topics. We don't have anyone signed up. And item 9A, general council business, update and discussion of Muskogee Creek Nation allotment owned by Steve Bruner, located between Creek Turnpike and Tucson, west of Olive, and city limits of Broken Arrow. Beth Anne.
Yes, sir. The city manager had asked that I update you all, as well as Broken Arrow citizens, on the status of two separate lawsuits that had been filed regarding the subject property. Probably the first one that I will start with involved an action that was filed by the Kylie Tribal Town and Red Creek Holdings, LLC, against the Attorney General of the Muskogee Creek Nation, the Chief of Police of the Muskogee Light Horse, and a number of others that were involved in the circumstances that occurred last month. You may recall that the Creek Nation had issued a press release, I believe, or at least kept the press up to date on some occurrences at this particular piece of property. And basically what happened was the court had, the tribal court had issued a search warrant and an arrest warrant for Mr. Bruner, and that was executed by the Light Horse. And so the Light Horse, pursuant to the warrants issued by the tribal courts, actually went in, seized the property, seized the gaming machines, and they arrested Mr. Bruner, and he has been charged criminally. Well, as a result of that, the Kylie Tribal Town and Red Creek Holdings, they brought an action in the United States District Court for the Northern District of Oklahoma, which is, of course, in Tulsa. They brought an action, and they cited quite a bit of case law, basically claiming that the Kylie had dual jurisdiction over that particular parcel, and that the Muskogee Creek Nation had no authority to take the action that they did. They also asked for injunctive relief. Fairly quickly, Judge Egan, who is one of the presiding federal judges in the Northern District, dismissed their petition. She basically found that there was no subject matter jurisdiction. And so, you know, if you go back to law school 101, as the council member or vice mayor knows, you know, only two ways to get into federal court. It's diversity of citizenship and federal question. And what they were trying to do was get into federal court in the Northern District by way of alleging that the National Indian Gaming Commission in IGRA, the federal Indian gaming law, was pertinent and actually was sort of the basis for this. And Judge Egan, by her own motion, which she is entitled to do, wrote a relatively short opinion compared to many of the opinions that we've seen lately. It was 8 pages, and she said, yes, you don't have subject matter jurisdiction, so you know, you can amend, but we'll see. Then in Washington, D.C., back on August the 17th, so it would have been just about the same time that this was transpiring, the Kylie Tribal Town filed an action in the United States District Court for the District of Columbia, essentially appealing the denial of the gaming request before the NIGC to game at this particular location. And so that I had my paralegal get on and check it on Racer, and right now they've issued a series of summonses. And one thing that's a little bit interesting, you know, they've named the chairman of the NIGC, they've named the United States Department of the Interior, they've named the Assistant Secretary for Indian Affairs and Secretary of the Department of Interior. I'm pretty sure Santa Claus is named in here somewhere, but he wasn't specifically referenced. So in any event, this is basically the way that they get relief from the NIGC. One thing that was just a little bit concerning to outside counsel and me was the fact that the attorney who wrote the opinion initially about the tribal town and denial of it, of their request to game, or the opinion in support of it, hopefully I got this right, She is now actually working for the Kylie Travel Town. So, and offering her counsel and advice, I guess. I haven't delved too much into that, but I suspect there's probably going to be a lot more activity in federal court with regard to these. They may or may not file an amended motion or a new petition for relief. My suspicion is that the D.C. Circuit is fairly adept in handling appellate matters for denial of certain administrative action. So my suspicion is that they will deal with this in relatively short order, although they may not. We discussed the possibility of intervening in one of the actions, and so that might be action that the council wants to take, or of course we could wait and see what the resultant action is. So I will probably have some discussions with the city manager about this and discuss whether or not you all want to talk about that in executive session. We did have an occasion to visit with the attorney for the Kylie Travel Town and Red Clay Holdings, and he advised that they have prepared a paper which demonstrates that the travel town actually has joint jurisdiction over this particular parcel, and allegedly that was the result of his cross-examination done in the previous action involving the allotment owned by Marcella Giles. Now, further complicating all of this was a 131-page opinion that was issued by the 10th Circuit Court of Appeals on August the 8th. And it was a 3-judge panel, and it was actually a criminal matter where an individual was given the death penalty in state court. And the individual argued that the state of Oklahoma had no ability to prosecute him because basically the entire side of the state remains a Creek reservation. Cherokee also. Remains a reservation because Congress never disestablished it. And our thought was that the justice that wrote the opinion felt fairly confident in his position, since he took 130 or so pages to say that. It's my understanding that the state attorney general's office has filed a request for it to be heard in en banc or in bank, depending on what side of Oklahoma you're from. you say it that way, but to get the whole panel involved in this. This is something that has far-reaching implications for the city of Broken Arrow in terms of law enforcement, prosecution, weed lots. I mean, it's astonishing. It goes on and on and on. And it was kind of interesting because I heard one person refer to this as the dog that caught the car. And I thought that was probably a really appropriate visual for what this opinion represents. In any event, this is also something that I will discuss with the city manager in terms of putting it on for executive session. Not entirely, I don't know that we would have the ability to intervene, but we certainly absolutely need to entertain filing an amicus brief. The day after this opinion came out, we reached out to all the Oklahoma Association of Municipal Attorneys, the District Attorney, Oklahoma District Attorneys Council, Santa Claus. I mean, we called everybody trying to get them very interested in this. We also notified Chuck Thompson, who's Executive Director of IMLA, and we're in the process of trying to obtain a national firm to write an amicus. One great thing about membership in IMLA is you can get the really large firms sometimes to write amicus briefs because municipalities couldn't otherwise afford to do it, and they'll do it on a pro bono basis. So we're right now researching firms. I think the original firm out of Albuquerque, I think that they were interested in compensation, and that was just not something that we were willing to discuss, at least at this point. So anyway, I will be happy to answer any questions.
Has there been any discussion, should the leader of the Kylegi win his election seat for the council in the Creek Council, how that impacts all of this? You know, he's running for council.
I did.
So it just adds another layer of.
Has a decision been made on that? Because I know that
The election board ruled he could run.
Yeah, they did. And so I don't honestly know what the implications of that would be. And I got to tell you, this 130-page opinion came out of nowhere. In fact, I had previously, the Assistant City Attorney Leslie Myers had done considerable research on it because on this, it was actually this case that we utilized when we were making the recommendation on the determination as to whether or not to remove a water line that was located within the statutory right-of-way and abutting an existing allotment. Because the initial court Oklahoma ruling was we felt very solid and right on point. And so we knew that this had been, that a habeas had been filed and sent to the 10th Circuit, but I don't know that anybody anticipated this result, would be my guess.
So if our thing was they couldn't have dual citizenship, their own election board kind of threw that out.
It certainly helps the
But
position.
I do think, I haven't seen a rescission I think there's a case that determines that you can't exercise joint jurisdiction over a piece over the same piece of property, if I'm not mistaken. Perhaps I'm dreaming that up, but I believe I had read that had been decided at some
I think
point.
that's their position, and that came from the previous rulings. But at least from my humble opinion, there have been so many developments within the month of August from a legal perspective. Even with a magic 8-ball, I don't know that I could, predict. But you're right. That certainly was our position, as the Creek Nation has authority and jurisdiction over this land. That was what was previously held by the NIGC, and hopefully the D.C. Circuit Court will uphold it.
Well, I think it's, from my viewpoint, I thought it was encouraging to note that Judge Egan had taken this upon herself sui sponte to make a ruling, which means no one petitioned her to make a ruling. She just did it on her own, which means she had a strong sense of what the case looked like, the Northern District case. I don't anticipate that the Washington, D.C. District will do the same thing at this point, based on the pleadings. But a reading of her opinion, Judge Egan's opinion, I thought was instructive into how it's truly going to come down to, I think, what the D.C. District says, because I think that's their path, if they have one.
Any more comments or questions? Thank you, Beth Ann.